Well, let's stay with this because the National Prosecuting Authority's spokesperson, Advocate Mthunzi Mhaga, joins me now for where to from here. Advocate Mhaga, good evening to you. Thank you for your time. Let's start with the civil case that now seems to be afoot. The family of Moroadi Cholota indicating very strongly that they are going to sue the NPA for what you did to her. Is there a response from your end as to whether or not you're willing to defend this, or are you going to pay up?
Good evening, Toli, and good evening to your viewers. In the absence of any formal summons and with a clear cause of action being outlined in those summons, which would have been served or would be served on the NPA, it is difficult for us to comment on it. Safe to say that I'm not sure on what basis they would be mounting such a civil claim, given the fact that the judge and throughout the trial, within a trial, the merits of the case, the charges that she is facing were not ventilated, nor were they adjudicated, which would then warrant a civil lawsuit against the NPA.
Is there any doubt, though, that there was wrongdoing on the part of the NPA in your extradition of Ms. Cholota from the United States? Why did you not involve the Department of Justice?
Only when the extradition application was made, the processes that were applicable at the time, the regime on extradition process and application was followed. And then there was the SCA judgment of suits, which pronounced that the Minister of Justice is the requesting authority entrusted with the power to make the application. Now, at that time, obviously, the application had already been made. And I think 2 months later, the judgment of the magistrate court in the United States of America was granted. We are now in the process of appealing that suit's judgment, given the implications of it being retrospective in its application, because of its implications on a number of extradition applications that have already been processed in terms of the previous regime before the ruling of the SCA. It is on that basis that we are seriously considering whether we have solid grounds upon which we can mount an appeal, given the fact that the appeal on to the Constitutional Court on the suit's judgment is still pending. So there is nothing that I believe the National Prosecuting Authority could have done in the circumstances, given the fact that the application was not made after the SCA judgment.
Yeah. All right. So how soon then can the South African public know whether or not you are going to appeal what effectively happened today, and that is that Ms. Cholota, as things stand, is a free person?
Today, the team is reflecting on the judgment that was delivered by Loubser J. And tomorrow we will have an engagement. And I'm not sure if by that time the prosecution team will be ready to make an announcement on whether we are appealing or not.
Let's discuss the status of Ms. Cholota. Is she still part of this case? Because as I said a little earlier, the understanding is that she's a free person. If she is still going to be a witness, on whose behalf?
Currently, her status in the case itself is that the court ruled that we lack, or this court lacks jurisdiction to try her matter, which means that there can never be criminal proceedings against her and in relation to the charges for which she was extradited, because the court has ruled. until such time that the prosecuting authority successfully appeals the judgment of Loubser J, which in its essence has the effect of a final order. It is on that basis that the South African law allows the state or any other party to appeal a judgment that has the effect of a final order. So as things stand, she cannot be involved in the proceedings that will be resuming tomorrow.
And that has major implications for your case, because part of the reason we heard, even though the judge did not rule on these matters, but the fact that she was intimidated, the fact that the South African authorities, in trying to extradite her, not only intimidated her, but they lied to U.S. authorities about whether or not she could be or was a flight risk. How heavily reliant were you as the prosecuting authority on her in order to convict some of the co-accused?
Polly, let me explain this thing in simple terms. When the trial within a trial started, it was triggered by a special plea of lack of jurisdiction on the part of the court from Ms. Cholota. She did so in her capacity as an accused person in circumstances where the state has evidence implicating her. She is not, and on record, we've made it clear, she is not a state witness, and therefore her being cleared at this stage in terms of facing charges for which she was extradited has no bearing on the charges that the other accused will face when the trial resumes tomorrow, because she was an accused person, not a state witness, in respect of which the prosecution relied. I hope I am clear.
Very clear indeed, sir. Let's conclude the conversation then. And can I bring a completely different matter? And I apologize if you weren't ready to comment on this, but it would appear, just on the face of it, that the two matters almost mirror each other, even though the merits of the cases differ completely. Would I be completely offline to say that what has happened in court today may give Dr. Nandipha Magudumana a fighting chance at the Constitutional Court in the manner in which she was brought to South Africa by South African authorities working with their Tanzanian counterparts?
Oh, thanks, Tolly, for bringing that up. You are not ambushing me in any way because I'm au fait with the issues that relate to the NPA. I'm hands-on and very intimately involved. These are two different processes. We have an SCA that has said majority of judges, the deportation of Dr. Magudumane was above board and therefore dismissed her application or appeal. That was a deportation, not an extradition order that facilitated her return to South Africa from Tanzania. When it comes to Ms. Cholota, it is an extradition order in respect of which a judgment has been made that the court lacks jurisdiction. So those are two distinct processes. And fortunately for us, we have a majority of 4 judges which ratified the deportation of Dr. Magudumana. Only one dissenting judgment has upheld her appeal, in respect of which yesterday we received a petition that they will approach the Constitutional Court. We will rely on the argument we made previously and the majority judgment which ruled in our favor that the deportation was a seamless above-board process. Therefore, the application for leave to appeal to the Constitutional Court, which is the apex court in the land, should be dismissed.
Advocate Mhaga, it's a final question, and briefly, if you can, I know I've kept you for long. There are those who are watching this and saying, once again, the NPA has egg on its face. What now in terms of your reputation and trying to rebuild this image? It doesn't seem to be working, does it?
Only the criticism and the perception of slow pace in getting convictions in these matters is understandable. But I will caution against pressing a panic button at this stage, given the fact that it is one accused in respect of which no adjudication of merits, of strength of the state case was had during the trial within a trial. Tomorrow, the trial resumes in respect of the rest of the accused. And I don't think, therefore, people should start panicking.
Advocate Mthunzi Mhaga, thank you very much indeed for your time speaking on behalf of the National Prosecuting Authority.